Nemo Quod non Habet
Nemo Quod non Habet
is an important concept in property law, both for when it applies and when it doesn't. The phrase translates to "no one can give what they do not have." The concept is simple. Suppose you buy a stolen watch from a thief. Even though you're innocent, you didn't know that the watch was stolen. You would still have to turn it over if the original owner shows up and wants it back. Now, why is that? Well, your rights to the watch come from the fact that you bought it from someone, and that person was a thief. And the thief cannot transfer rights that they don't have. Of course, you would still have a cause of action against the thief if you can find him, but against the original owner, you're out of luck. Now, that's pretty simple. But sometimes the law creates exceptions to the Nemo principle. We're going to discuss one of them in this video. Section 2-403 of the Uniform Commercial Code says that a person with voidable title has power to transfer a good title to a good faith purchaser for value. The provision has a separate exception concerning entrusting goods to merchants. We're just going to stick with this exception for this video. So what is voidable title? It's a right to a piece of property that can be, voided. So suppose I buy a watch from you in exchange for a check. Suppose that I don't actually have the money in my checking account to cover the check. That is, it bounces. What happens when you find out? Well, you can sue me to cancel the deal and recover the watch, and the court would order me to give the watch back to you. Same thing if I used fraud to get you to give me the watch. Say I falsely tell you that it'll be used in a charity auction and you give it to me with that understanding. Or suppose I promise to pay you later, but I have no intention of doing so. Either way, once you learn of my fraud, you could undo the transaction, but just because you can reclaim the watch doesn't mean that you will. In other words, my right to the watch is voidable, but not actually void until you act. Until then, the watch is mine. It's just that my ownership isn't as secure as it would have been if I had never done anything wrong. We might think of my title as being encumbered, burdened by the possibility that you will emerge to assert a superior claim to the property, in much the same way that many people's ownership of their homes is burdened by a mortgage, the possibility that the bank will foreclose if the owner fails to make mortgage payments. Now here's the tricky part. Suppose, before you can void the deal, I sell the watch to an innocent buyer who didn't know about my misconduct, a good faith purchaser for value. What happens then? Under the Nemo principle, I should only be able to transfer what I have. So if I have voidable title, that should be what I transfer. The rights I give the purchaser should therefore be subject to the legal claim of the person I tricked. But no, the UCC says that if I sell the watch to a good faith purchaser, that is, they don't know about my wrongdoing, then I can transfer more than what I have. I can sell good title to the watch. That sounds harsh to the wronged original owner, doesn't it? Why would the law do things this way? One answer might be that you should have been more careful. After all, you didn't have to take my check, you could have demanded cash, or you could have insisted that an escrow agent hold the watch and not deliver it to me until my check cleared. And in the fraud scenario, maybe you should have known that I'm not to be trusted. I mean, look at me. If by contrast, the person to whom I sold the watch didn't know about my misconduct, then maybe it makes sense to protect them. We might go a little further and argue that we want to protect people like my buyer, because if we didn't, we might scare honest people away from making purchases. After all, wouldn't you be less likely to make an everyday purchase if you knew that a former owner might emerge and take the good away from you based on a claim that they had been tricked into selling it? If we think that markets and transactions are good things in general, then maybe we want to promote them by providing protection to good faith purchasers. Now, of course, we could make the same claim about stolen property, but maybe there we think that people already do their best to keep their stuff from being stolen. Or maybe we think that stolen property is more likely to be sold in circumstances in which the purchasers ought to be suspicious. Or maybe we think it's too unfair to the original property owner to deprive them of the ability to get their stuff back when they never intended to part with it. Or maybe we're afraid of incentivizing theft and follow-on sales to purchasers who claim to be acting in good faith but really aren't. But the point here isn't that the law is drawing the line perfectly. We can argue about that. But just to note that there may be good reasons to depart from the strict Nemo rule, and sometimes that is what the law does. Here are a few other things to keep in mind. In voidable title cases, when we say that there is no cause of action against the good faith purchaser, that doesn't mean that the original owner has no claim against the wrongdoer. If I buy a watch from you with a bounced check, you can still bring a claim against me, even if I sell the watch to a good faith purchaser. The UCC rule protects the person who bought from me, not me, so I'm still liable to you for damages. Now that may be small comfort to you if I ran off to someplace where the law can't reach me, but you still do have a remedy. And note also that this exception only covers good faith purchasers. That means that if I give vibes that put my purchaser on notice that something's up, say I try to sell a $5,000 watch for just $1,000, then my buyer doesn't get the benefit of the UCC rule. Likewise, suppose I commit fraud to get you to sell me the watch and I then gift the watch to an innocent party. The beneficiary of my gift doesn't get to rely on the UCC's exception to Nemo. This makes sense. If we want to encourage people to trust their transactions, then it makes sense to only protect those who relied on them. That is, people who actually paid money. By contrast, losing a gift, it's a bummer, but it usually just puts the recipient back where they started. It's less likely to have the same kind of demoralizing effect of telling someone that they have nothing to show for their purchase. Now, the UCC rule is just one exception in property law to the Nemo. Principle. There are others. Most importantly, the role played by the recording acts in land transactions. These statutes are going to be the subject of a series of future videos. But for now, it's good to get comfortable with the idea that there is a baseline and the possibility of exceptions to them, as well as the importance of reading and applying these exceptions precisely. To that end, if you're so inclined, here are a few Nemo. UCC review problems. In all these problems, A is the original owner of a valuable watch to which B gains possession due to some kind of wrongdoing before transferring possession to C. Let's start with some easy ones. A owns a watch. B steals the watch and sells it to C, who is a good faith purchaser for value. What can A recover against B? What can A recover against C? So here, the basic common law Nemo. Rule applies. A, of course, has a claim against B that might result in B's being ordered to pay A damages. As for C, B can't sell what B doesn't own. Therefore, all B can transfer to C is a right of possession that is inferior to A's ownership interest. A can therefore recover the watch from C. C would then have a claim against B for selling C a watch without owning it. The UCC is no help to C here, because B never had title of any kind. It also makes no difference that C was a good faith purchaser. All right, next one. B buys a watch from A and pays for it with a check drawn on a bank account that has insufficient funds. That is, the check bounces. B immediately sells the watch to C, who is a good faith purchaser for value. A sues to recover the watch. First, as before, A has a claim against B for damages. But this time, A has no claim against C because the UCC changes the background Nemo. Rule. The ownership interest that A transferred to B is voidable, not void, because A has the right to undo the transaction, but A has to act for the transaction to be undone. It still happened. Until A acts under the UCC, B can transfer clean ownership of the watch if C is a good faith purchaser without notice of B's misconduct. The facts of this question say that that's what C is, so C gets to keep the watch. Next, same facts as before. But this time, C buys the watch for a quarter of its appraised value. Let's say that C pays $1,000 for a $4,000 watch. Now there's room for A to argue to a court that C should have known that there was something wrong with the transaction. If so, then C would not be a good faith purchaser. Note that a court does not necessarily have to find this. It would be a fact question subject to lawyering in court. But if a court agrees with A, then the UCC would not protect C, and we'd be back to the common law baseline of Nemo. All C would have would be voidable title, because that's all that C got from B, and A could undo the original sale to B, and therefore recover the watch from C. Next, B buys a watch from A and pays for it with a check drawn on a bank account with insufficient funds. B immediately gifts the watch to C, who is acting in good faith. A sues to recover the watch from C. This time, C definitely loses. Why is that? Well, what happens under normal Nemo dot principles? Under normal Nemo dot principles, C does not get clean title to the watch because A has the right to void the transaction with B. Because B cannot give what B doesn't have, B transfers the voidable title to C, who would lose when A voids the initial sale to B. So if C is going to win, C needs help from the UCC. So what does C need to win under the UCC? To be a good faith purchaser for value, C is acting in good faith without notice of the voidability of title, so check. But C also needs to be a purchaser. C fails this condition because C is a donee. The UCC therefore does not apply, so C loses under the common law Nemo dot rule. Last one. B buys a watch from A and pays for it with a check drawn on a bank account that has insufficient funds. B immediately sells the watch to C, a good faith purchaser for value. C then gifts the watch to D, but D knows about B's bounced check. A sues D to recover the watch. Who gets it? Now think about this one. All right, so the answer is that D wins. Now, I imagine many of you are thinking, wait a minute, the UCC only benefits good faith purchasers, and D was neither a purchaser nor acting in good faith. What gives? Let's break it into pieces. First, B buys the watch with a check that bounces. So what does B have? B has voidable title, but we also know that C may get the benefit of the UCC. What does C need in order to have received good title from B? C needs to be a purchaser, check, who acts in good faith without knowledge of any problems, check. That means that C is protected by the UCC, and that means that C owns the watch free and clear. But what does it mean to say that C owns the watch? It means that C has the full bundle of sticks that classify property ownership. That means that C can use the watch, share the watch, leave the watch in a will, destroy the watch, sell the watch, and, yes, give the watch away. So when D receives the watch, D is receiving a grant of C's rights, and those are the rights of full ownership. Stated another way, we know that when C buys the watch, C acquires full ownership. If we turn around and say that C can't give the watch to D, then we would be saying that C never truly owned the watch. But we know that C did acquire good title. That means that C has the right to gift clean title in turn. Okay, you might ask, but what about the fact that D both knew about B's bad actions and that D is a donee? It doesn't matter. Those facts would matter if D were seeking the protection of the UCC. But D is not seeking the protection of the UCC. D is only relying on C's rights. C's rights, of course, do depend on the UCC, but C fulfilled the conditions of the UCC and is therefore protected by the statute and is free to convey good title to D.